Article 5 is not coming to mind at the moment.
Okay. How about Article 2? Have you ever tried a jury trial?
I have not.
Civil?
No.
Criminal?
No.
Weapons. Weapons would be something that members of Congress would defend.
Is slamming a federal judge's ruling that overturns the state's 3-decade-old ban on us.
The legislature can pass whatever it wants. It's just not going to stand up once it gets into the court.
I'm an eternal optimist, but I am also a committed realist.
Biden judicial nominees stumped. The recent confirmation nominees, Judge Cato Cruz and Judge Charnel Bielkengren, have sparked significant attention due to their inability to answer basic legal questions posed by GOP senators. These instances raise concerns about the nominees' preparedness for their roles on the federal bench and highlight broader issues surrounding judicial nominations and confirmation process in the U.S. Firstly, let's delve into the specific questions that both nominees struggle to answer. Judge Cruz, nominated for the U.S. District Court for the District of Colorado, was asked by Senator John Kennedy about the concept of a Brady motion. This legal term derives from the landmark Supreme Court case Brady v. Maryland, which established that prosecutors must disclose evidence favorable to the defendant. However, Judge Cruz failed to provide a coherent answer, mistakenly associating the Brady case with the Second Amendment instead of its actual context in criminal procedure. Similarly, Judge Bielkengren, nominated for the U.S. District Court for the Eastern District of Washington, struggled to respond when asked about fundamental aspects of the U.S. Constitution by Senator Kennedy. She couldn't identify the roles of Article 2, which delineates executive powers, and Article 5, which outlines the amendment process.
Tell me what Article 5 of the Constitution does.
I'm an eternal optimist, but I am also a committed realist.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Neither is Article 2.
Okay.
These lapses in knowledge are particularly troubling, given that these concepts are commonly taught in high school government classes and are fundamental to understanding the U.S. legal system. These instances raise questions about the vetting process for judicial nominees. While it's natural for nominees to face challenging questions during confirmation hearings, their inability to provide basic answers on foundational legal principles suggests a lack of preparation or familiarity with core aspects of their prospective roles. This raises concerns about their qualifications and readiness to serve as federal judges. Furthermore, these incidents highlight the contentious nature of judicial nominations in the U.S. political landscape. Nominees are often subject to intense scrutiny and questioning from senators, especially those from opposing parties. In this case, Republican senators have seized on these moments of uncertainty to cast doubt on the nominee's suitability for the bench. Such incidents can fuel partisan debates and potentially influence the confirmation process. However, it's important to note that judicial nominees' performance in confirmation hearings is just one aspect of their qualifications. While the ability to answer legal questions confidently is important, it's not the sole determinant of a nominee's suitability for a judicial position. Factors such as legal experience, temperament, integrity, and judicial philosophy also play crucial roles in evaluating nominees. In response to these incidents, some may argue for reforms to the judicial nomination and confirmation process. This could include enhanced vetting procedures to ensure nominees possess adequate knowledge of legal principles and procedures. Additionally, there may be calls for increased transparency and accountability in the nomination process to provide the public with greater insight into nominees' qualifications and background. Ultimately, the confirmation process for judicial nominees is a complex and multifaceted endeavor that requires careful consideration of various factors. While instances of nominees struggling to answer basic legal questions may raise concerns, it's essential to approach such situations with nuance and to evaluate nominees holistically. As Judge Cruz and Judge Bielkengren's nominations proceed, The Senate Judiciary Committee will continue to scrutinize their qualifications, and their performance in confirmation hearings will undoubtedly be a significant factor in the committee's deliberations. Questions about Constitution. A judicial nominee of President Joe Biden was apparently stumped by Senator John Kennedy's basic questions about the Constitution during her Senate confirmation hearing Wednesday. Spokane County Superior Court Judge Charnel Bjelkengren, who was nominated to be a U.S. District Judge for the East District of Washington, couldn't answer when Kennedy pressed her about articles of the nation's founding document. "Tell me what Article 5 of the Constitution does," Kennedy asked as he began his round of questioning. "Article 5 is not coming to mind at the moment," Bjelkengren replied. "How about Article 2?" Kennedy asked. Bjelkengren replied that didn't come to mind for her either. Article 5 of the Constitution outlines the process for amending the founding charter, and Article 2 details the executive powers vested in the President of the U.S. Kennedy's harsh questioning of judicial nominees has stopped a nominee from being confirmed before. Matthew Peterson, a lawyer and former Federal Election Commission chairman nominated by then-President Donald Trump to serve on the U.S. District Court for D.C., withdrew from consideration in 2017, following a cringe-worthy exchange with Kennedy that went viral. Peterson, who had never tried a case, could not answer Kennedy's basic law questions either.
Have any of you not tried a case to verdict in a courtroom?
President Trump's judicial nominees going viral for the wrong reasons as Trump comes under fire for his nominees' qualifications.
To the confirmation hearing going viral, one of President Trump's nominees for federal judge questioned.
Have you ever tried a jury trial?
I have not.
Civil?
No.
Criminal?
No.
Kennedy told NBC News after the hearing, "Some of these nominees that have been forced in the last 2 years have no business being anywhere near a federal bench. They don't have any business being anywhere near a park bench." He added, "I don't ask the nominees, do you support this precedent or do you support that precedent? I ask them to tell me about the law. Tell me what the Constitution says. Tell me about the relationship between the federal judiciary and our administrative agencies. These are all very basic questions." The withdrawal of Matthew Peterson. The withdrawal of Matthew Peterson's nomination for a federal judgeship after his widely publicized struggle to answer basic legal questions during his Senate confirmation hearing underscores the complexities and challenges of the judicial nomination process in the U.S. Peterson, a lawyer and Republican member of the Federal Election Commission, became the latest in a series of Trump's judicial nominations to falter, raising questions about the vetting process, the qualifications of nominees, and the broader implications for the federal judiciary. The viral video of Peterson's confirmation hearing, in which he appeared unable to provide satisfactory answers to rudimentary legal queries posed by Senator John Kennedy, drew widespread attention and scrutiny. Kennedy's questioning, while perhaps unconventional in its directness, revealed significant gaps in Peterson's legal knowledge and raised doubts about his readiness to serve as a federal judge.
About his experience, admitting he has never actually tried a case in court, and it just went downhill from there.
2 of them were withdrawn, one nominee failing to answer basic legal questions and admitting to a stunning lack of experience as well.
The questioner, Louisiana Republican Senator John Kennedy, says he supports the president and he was just doing his job.
Do you know what a motion in limine is?
I would probably not be able to give you a good definition right here at the table.
Senator Chuck Grassley's announcement that the nominations of Jeff Mateer and Brett Talley would not move forward due to controversy and criticism further underscores the challenges and complexities of the confirmation process. Mateer faced scrutiny for past statements deemed offensive and inappropriate, while Talley's failure to disclose relevant information raised concerns about transparency and integrity. The scrutiny and challenges facing Trump's judicial nominees reflect broader debates and divisions within the political and legal landscape. Questions about nominees' qualifications, judicial philosophy, and adherence to legal principles are central to the confirmation process and reflect differing priorities and perspectives among senators, interest groups, and the public. The withdrawal of Peterson and other nominees underscores the significance of these debates and the importance of thorough vetting and scrutiny in the selection of federal judges. Despite these setbacks, Trump has made significant progress in filling vacancies on the federal courts with conservative judges, a key priority for his administration. The appointment of Justice Neil Gorsuch to the Supreme Court, along with numerous appointments to lower courts, has reshaped the judicial landscape and solidified conservative influence in the judiciary. This legacy will have far-reaching implications for legal precedent, public policy, and the balance of power within the federal government. Answering the questions. President Joe Biden wants Congress to ban attack weapons, but so does David Chipman, his nominee to run the Bureau of Alcohol, Tobacco, Firearms, and Explosives. But neither Biden nor Chipman will say what that term means, and their obfuscation makes it impossible to take their proposal seriously. Chipman, who worked as an ATF special agent for 25 years and later served as a senior policy advisor to the armed control group Giffords, was repeatedly asked to define attack weapons during his Senate confirmation hearing last month, and he repeatedly dodged the question. Given Chipman's long experience as both an ATF agent and an armed control advocate, his evasiveness cannot plausibly be ascribed to a lack of preparation or knowledge. Instead, it seems to be an intentional strategy designed to avoid exposing the illogic of targeting arms based on their military-style appearance. "I have a simple question for you," Senator Tom Cotton said. "What is an attack weapon?" Chipman's answer not only was not simple, it was not really an answer at all. An attack weapon would be, in the context of the question you asked, whatever Congress defines it as, he told Cotton. That much is true. The attack weapon legal category was invented by politicians, who define it however they want. But in the context of the question that Cotton asked, the scope of the federal ban that Biden and Chipman support, that observation clarified nothing. The senator wanted to know which arms Chipman thinks Congress should ban, and the nominee replied that Congress would have to make that decision. "You're asking us to ban attack weapons," Cotton noted. "We have to write legislation. Can you tell me what an attack weapon is? How would you define it if you were the head of the ATF? How have you defined it over the last several years in your role as an armed control advocate?"
Weapons.
Weapons would be something that members of Congress would define.
But he has not responded to our question of whether he will vote to confirm the nominee he questioned.
A moment in Congress that is going viral this morning.
How do you define it? You're going to be running the agency.
Chipman tried a different dodge, referring to an ATF requirement that federally licensed arm dealers near the southern border report multiple sales of certain rifles. That program, he said, has defined an attack rifle as any semi-auto rifle capable of accepting a detachable mag that holds ammunition above the .22 caliber, which would include the .223, which is largely the AR-15 round. That definition is much broader than the ones used in the 1994 federal attack weapon ban, which expired in 2004. The new supposedly improved version, backed by Senator Dianne Feinstein, and state bans such as California's, which a federal judge recently deemed unconstitutional. While those laws do not refer to caliber, they list forbidden features such as folding stocks, pistol grips, barrel shrouds, and flash suppressors. Since the ATF definition requires none of those features, it covers many arms that remain legal in California and would remain legal under Feinstein's bill. Feinstein's attack weapons ban of 2021 specifically exempts the Iver Johnson M1 carbine and the Ruger Mini 14 rifle, for example, as long as they have fixed stocks. Although a folding or adjustable stock does not make these arms any dangerous or render them easily concealable, Feinstein thinks it is enough to transform legitimate arms into arms that are good for nothing but mass slaying, which gives you a sense of the puzzling distinctions drawn by such laws.
President Joe Biden has called on Congress to ban weapons. From the White House, he said it was time to act.
We need to ban weapons in high-capacity magazines.
Is slamming a federal judge's ruling that overturns the state's 3-decade-old ban on assault.
Nobody can seriously argue that you have to have this kind of a weapon for self-defense.
The definition that Chipman cited, by contrast, encompasses both of these arms, regardless of whether they have fixed stocks. It would also cover the stripped-down California legal versions of AR-15 style rifles and all hunting rifles that accept detachable mags and fire anything larger than 22 rounds. Cotton asked Chipman if he was suggesting that Congress should ban all of these arms which lack the features that legislators have always used to define attack weapons. Chipman wouldn't say. You asked me if ATF had used this term, and I was sharing with you my knowledge of a program in which ATF has defined this term, he told Cotton. But while the senator mentioned Chipman's possible role as director of the ATF, he also asked how Chipman has defined an attack weapon as an arm control advocate. Although that should not have been a hard question, answering it would have invited uncomfortable follow-up questions about the arbitrariness of attack weapon laws. Instead, Cotton made that point directly. I think our exchange here illustrates that there really is no such thing as an attack weapon, he said. That is a term that was manufactured by liberal lawyers and pollsters in Washington to try to scare the American people into believing that the government should confiscate weapons that are wildly popular among millions of Americans to defend themselves and their families and their homes. Later in the hearing, Senator John Kennedy also asked Chipman to define attack weapons. Chipman responded in the same maddening way he had to Cotton's question, saying attack weapons would be something that members of Congress would define. When Kennedy pressed Chipman to say how Congress should do that, and noted that he had 35 seconds left in that round of questioning, the nominee claimed it was impossible to give a brief answer. The bill to ban attack weapons is thousands of pages, he said. There's no way I could define an attack weapon in 35 seconds. Presumably, Chipman knows attack weapons when he sees them, but that subjective approach is inconsistent with the rule of law. Contrary to Chipman's claim, Feinstein's bill is not thousands of pages. It is 125 pages long, and most of that space is devoted to a redundant list of specifically permitted models. The general definition of rifles that qualify as attack weapons is just a few paragraphs. It includes any semi-auto rifle that accepts a detachable mag and has a pistol grip, a forward grip, a folding or telescoping stock, a grenade launcher, a barrel shroud, or a threaded barrel. Assuming that Chipman's definition is similar, he easily could have said so even in 35 seconds. But then he might have been asked how these features, which have nothing to do with caliber, rate of fire, or muzzle velocity, make attack weapons an intolerable threat to public safety. Biden himself has conceded that the 1994 attack weapon ban had no impact on the lethality of legally available arms, precisely because manufacturers could comply with the law simply by eliminating the targeted features. The president supports a new ban that would somehow stop arm manufacturers from circumventing the law by making minor modifications to their products, modifications that leave them just as fatal. But Feinstein's bill would not accomplish that feat, and Biden has never explained how a ban based on a similar approach possibly could. Chipman's reticence is of a piece with Biden's vagueness. It is impossible to rationally debate the merits of a policy when its advocates refuse to explain what they have in mind. That seems to be the point.
Strengthen background checks, enact safe storage law and red flag laws.
Following a string of high-profile mass shootings, and appealed to Congress not to let the American people down.
The ban also faces legal challenges in federal court.
The legislature can pass whatever it wants. It's just not going to stand up once it gets into the court.
Complexity of arm policy. President Joe Biden faced a significant setback when he was forced to abandon David Chipman, his nominee to head the ATF. This was the second time he was forced to withdraw, and it was a blow to arm control groups who have backed Biden's pick. One explanation arm control advocates often lean on when facing setbacks involves the power of the NRA. The NRA creates puppet politicians who do nothing but lie and continue taking the NRA's dirty money, according to March for Our Lives. Another arm control group, Brady, appealed to its donors to give more so they could stop the NRA and their bought and paid for politicians from enacting more permitless arm carry laws. The narrative is familiar. Arm control measures can never pass because the NRA forbids it. The group buys off politicians with its incredible campaign spending. However, the reality is starkly different. In the 2020 election cycle, the NRA contributed less than $1 million directly to candidates, making it the 996th largest donor for the cycle. The group spent about $5.4 million on lobbying in that same time frame, which put it a bit higher at 169th. Since 2012, the NRA's highest contribution ranking has been 294th, and its highest lobbying ranking has been 85th. Congressional staffers from both sides of the aisle, several of whom asked not to be named so they could speak candidly, told me the NRA's campaign spending is not the reason restrictions on arm ownership or use haven't passed at the federal level in decades. The recent withdrawal of Biden's ATF nominee David Chipman shows how the group's influence plays out in practice. The senators on whom the NRA spent money to get elected did not deliver the nomination's knockout blow. Instead, Chipman's fate was sealed by Senator Angus King of Maine and Democrats Joe Manchin of West Virginia, Kristen Sinema of Arizona, and John Tester of Montana. The NRA is the weakest it's been in years. The party it spent millions trying to keep away from power now has full control of Congress and the White House. The President, Senate Majority Leader, and Speaker of the House vehemently support not just extending background checks for private arms sales, but instituting a more aggressive version of the attack weapons ban that Biden helped pass in the mid-90s. NRA membership hasn't grown in 8 years. In 2020, it mustered only about half of what it spent in 2016 to elect Donald Trump. Leaked financial documents indicate that its revenue dropped by more than $80 million over those same 4 years. The group also just failed in its attempt to declare bankruptcy and faces a dissolution suit filed by New York's Attorney General, stemming from corruption accusations against its executives, including CEO Wayne LaPierre. The NRA has even started to argue in court filings that the allegations against LaPierre should not be held against the group at large if they are found to be true. Democratic leaders can't seem to pass the arm policies they want, and it isn't because of the filibuster either. The Democrats can't get bare majorities to support their top arm priorities. They haven't passed an attack weapons ban since retaking the House in 2018, and even if it passed the House, it wouldn't pass the Senate. Senator Tester, an arm owner and staunch defender of Montanans' Second Amendment rights, is a key figure in the fight for arm control. The Democrats managed to pass 2 background check bills through the House on slim margins, but they are unlikely to pass the Senate due to more restrictions on arms sales and transfers than the Manchin-Toomey compromise that failed to pass the Senate in 2013. Both senators have publicly suggested that the House bills have even less support in the upper chamber than their deal did back then. The NRA is not buying off politicians with campaign donations, but it is far from powerless. The group is skilled at mobilizing arm owners with issue ads and other sizable independent expenditures, as well as through internal marketing aimed at mobilizing its members. As recently as 2016, it ranked in the top 10 groups nationally for outside spending on election campaigns. Even amid its other struggles, it still made the top 25 in 2020. During the fight over Chipman's nomination, the NRA spent $3 million on ads and mailers to encourage members and other arm owners to contact the moderate Democrats who ultimately stopped Chipman's confirmation. The NRA is not powerful because of its lobbyists, money, or PR. It is powerful because 5 million Americans decided they wanted to be members. Pro-Second Amendment advocacy is bottom-up, not top-down. The NRA uses a multi-pronged approach to advocacy that includes campaign spending, lobbying, and advertising, but relies primarily on members' influence. The real power is in the membership, as the majority of Americans care deeply about arm rights and know the NRA delivers. In 2021 alone, 5 states passed NRA-backed permitless arm carry bills. The NRA's lobbying efforts helped persuade even moderate Republicans to stand united against Chipman, which put further pressure on the Democrats, who ended up blocking his nomination. The NRA is also the only arm rights group with a nationwide lobbying apparatus. The group's professional approach to advocacy on the Hill is fairly unusual among groups on the right. The lack of new arm laws while the NRA's political opponents control the federal government has less to do with campaign spending or effective lobbying. Instead, it's a straightforward clash of ideas in a polarized nation. The two sides have deeply held beliefs that are in complete opposition to one another. If the NRA is effective, then that means the left groups aren't effective either. It's pretty much 50-50. When the rubber hits the road, you have to write a law and the details matter. The Democrats care about it just as much as we do, and they want to get it right, and sometimes they just don't agree. A lot of Americans own arms and value their arm rights, and that makes restricting access to them difficult even when the NRA is weak and its opponents are ascendant. That's all for this video, folks. See you next time.